Welcome to my second lecture. The dead cannot cry out for justice. It's the duty of the living to do so for them. Who investigates sudden deaths? I love this quote. Children have very little voice, and the coroner's inquest is about Luke's voice and making sure Luke is heard and respected and honoured. I don't want him to have died in vain. Rosie Batty. In the first lecture, in this lecture series, we talked about what happens when the state kills someone. We talked about what we would want the state to do, and we contrasted that with what the state actually does. Today, we're going into more detail about death investigations. How do we want death to be investigated? How are they actually investigated? What is our system doing that's right, and what is it doing that's wrong? How could it be improved? Let me set the scene. Our system of death investigations is very old. Think about how we would want the system to be if we were planning the system of death investigation from the beginning, if we were doing it from scratch. If we knew nothing about the system and we were designing the system, what would we want it to do? Well, first, we'd want it to be independent. We would want to be confident that the people investigating death are independent from persons or institutions that cause death, whether that be a private individual, a company, or government agency. We'd also want to be confident that they are independent from government and from party politics, so that there's no chance that the investigator is being leaned on to cover something up that is inconvenient or embarrassing. It's important not just that they be independent, but be seen to be independent. Secondly, we'd want those who are investigating the death to be competent and qualified. We would want everyone involved to be properly qualified for their role, to understand that role, and to undertake regular training and to keep up to date with the latest developments. Third, we'd want the investigator to be adequately resourced. They would have to have adequate staff and facilities to carry out a competent investigation. Where necessary, we'd want them to bring in outside experts. Fourth, we'd obviously want them to conduct a fair investigation. And that means that anyone who has a legitimate interest in the investigation, including the family of the deceased, has a fair opportunity to participate in the proceedings. We would expect the family, would we not, to have a chance to put forward their views at each stage of the process. We'd expect the process to be carried out according to consistent rules so that everyone involved knows what to expect and what will happen at each stage. Fifth and finally, we'd expect transparency. That doesn't mean that everything should be done in public, but it means that justice should be seen to be done, and in particular, the family of the deceased and other people with a legitimate interest should be told the truth about what is going on and should have the right to see documents and evidence. So, with this in mind, how does our system actually work? Is it fit for its purpose? When a person is killed in England and Wales, the person with the primary responsibility for investigating the death is the coroner. Of course, coroners are not the only people who investigate deaths. If a person dies in state custody, for instance, in a police station, the Independent Office for Police Conduct, or if they die in a prison, the Prison and Probation Ombudsman is likely to be involved. If a suspicious death happens in a hospital, the NHS Trust may do its own investigation and produce a serious untoward incident report. If there's a criminal investigation, the police or the Crown Prosecution Service will be involved. Some deaths are investigated by public inquiries, and so on. However, there are deaths and death investigations which are led by journalists, where officials fail. Over the years, there have been a number of very good investigative programmes that have taken up the gauntlet where officials have failed. And I'm thinking of programmes in the past such as World in Action, the BBC's Panorama, and a number of good investigative journalists in Channel 4. But let us not forget about the brave individuals and families who have had to conduct their own investigation where the state completely lets them down. I can think of many clients who would not rest despite officials telling them there was nothing untoward about a death. They persisted and conducted their own investigations, often at great personal and financial cost. The Sean Rigg family, who examined CCTV evidence for themselves and demonstrated that the official version that Sean Rigg had been looked at by a custody sergeant out in the police yard was patently and demonstrably false. Had the family not conducted their own painstaking research, that would never have been uncovered. Anne Power, whose husband honestly died in a road traffic collision following a police pursuit, doggedly rejected the police official version of events. And when she got an open verdict at the first inquest, refused to accept it. Eventually, after years, 20 years, she managed to persuade the High Court to overturn the verdict and order a fresh inquest. Susan Sutovic, whose son died in very suspicious circumstances. The official version was he had taken a drug overdose. And despite many legal setbacks and defeats, through just her own tireless determination, she eventually managed to get the case back to inquest and secured an unlawful killing verdict, that her son had been killed by a third party and his death had been staged. But despite the efforts of these brave individuals, sadly for every triumph, there are many more disappointments. The fact remains, coroners are the officials who have the primary responsibility for investigating sudden and unexplained deaths. And this lecture is going to focus mainly on them. So, the history of the coroner and his or her office. Let me start by looking at who actually does the investigation. I had originally had the more provocative title for this talk. You're kidding me? You really mean we have a judge who's been around for 900 years investigating sudden deaths? Well, yes, actually it is. You see, the office of the coroner is so old that even Geoffrey Chaucer makes reference to it. Quote, "Lord and sire, full often time was a knight of the shire, a sheriff had been, and a coroner." A quote from John Jarvis's book on coroners, first edition, 1829. You may be asking, so what exactly is a coroner? Well, as I've said, the office of coroner is the oldest judicial office in England and Wales, dating back to the 12th century. The office is mentioned as early as 1194. Chaucer's coroner was a knight of the shire. The office of coroner was historically reserved for the landed gentry. Even in the 19th century, a coroner was expected to be a substantial landowner in the county. Like the rest of the English legal system, the office of coroner was created by and for the ruling class. Originally, the coroner had many duties, but over the centuries, these have been whittled away. In modern times, the coroner ended up with two main duties. First, to carry out inquests into sudden and unexplained deaths, and the second, to inquire into treasure that has been found. The first of these is what we're interested in tonight for the purposes of this lecture. Coroners have always been local officials. For centuries, they were elected by the freeholders of a county. In the late 19th century, this was replaced with election by county council. Coroners are still appointed and paid by local authorities today. But coroners are judges. They have judicial independence. But they are unlike most other English judges because their role is inquisitorial rather than adversarial. In other words, they carry out investigations into sudden and unexplained deaths. They are assisted in their work by coroner's officers, who are normally either police officers or local authority staff on secondment. In some cases, a coroner is required to carry out a formal proceeding in court, and this is called the inquest, to decide how the deceased came by their death. Now, inquests only happen in the minority of death cases. The majority of deaths are never investigated by a coroner at all. They're simply certified by a doctor who was treating or last treated the deceased. Later in this lecture, we will look at whether a death has to be investigated by a coroner and whether an inquest has to be held. I couldn't give this talk without looking at the personalities of coroners. I want to look at this because it's an important factor that shouldn't be underestimated. You see, coroners have a lot of discretionary power over how an investigation is conducted. Whether the coroner is caring and compassionate or rude and hostile has a huge impact on the bereaved family's experience. This is especially so when emotions are running high in a courtroom. You can't be a good coroner unless you understand the trauma of bereavement. And I want to give you a couple of examples, both good and bad. First, a bad example. I was doing an inquest involving the death in custody, where the jury came back with a verdict which was a big disappointment to my clients, the family. One member of the family got very upset, shouted, stormed out of the courtroom. A reaction we can all understand when we feel that our loved one's death has not been fairly investigated. The coroner promptly lost her temper and shouted at me. She blamed me for failing to control my client. She even threatened me, saying that I was going to be appearing in front of her in a few weeks' time on another inquest, and said, "I hope on that next occasion you control your clients, not like on this occasion." She publicly shouted me down when I tried to respond to her. How do you think that made me feel? Aggressive, hostile, bullying behaviour, and more importantly, how do you think it made my clients feel? Compare and contrast that with the reaction of a different coroner when a mother whose son had apparently died from a drug overdose got angry and started shouting obscenities during the evidence of a witness. This coroner allowed this grieving mother to vent. Then he calmly said, "Mrs. X, I'm terribly sorry for your loss. I understand your frustration. Would you like a break now? We can resume in 10 minutes, or when you feel ready to come back into court. That calmed her down. She apologised. At the end of the inquest, she felt that she had been satisfied with the inquest process and had received a fair crack at justice. The 21st century, which we're now in, and the Luce report. Around the turn of the beginning of this century, there was a lot of criticisms about the coronial system for a variety of reasons. The system was viewed as inefficient, outdated, and fragmented, and there was a scandal from the failure to detect the activities of the GP and serial killer Harold Shipman in the 90s, who killed over 200 of his patients before he was detected. So the government of the day commissioned 2 reports. It commissioned a report into the coronial system generally, which was known as the Luce report, after its chair, Tom Luce. It also commissioned a separate inquiry into the Shipman case, led by Dame Janet Smith. The Luce report was published in 2003, and it identified a number of deficiencies in the coronial system. It commented on many deficiencies in the system, including the lack of any supervision or national leadership for the coronial service, the lack of clear participation rights for bereaved families, and the lack of standards for their treatment and support, and the lack of training for coroners and coroners' officers. It made 6 recommendations. These were as following. First, there should be a national coronial service made up of full-time, legally qualified professionals. The report called for the creation of a chief coroner to lead the service. It called for coroners to be appointed by the Lord Chancellor, like other judges, rather than by local authorities. It called for the introduction of an appeals process against coroners' decisions. Second, it recommended that there should be a family charter which would set out the rights of families in the inquest process. Third, each coroner area should have both a legally qualified coroner and a doctor working as a statutory medical assessor who would support the coroner in death investigations and would oversee death certification by doctors in the area. Fourth, it recommended that there should be a single process of death certification, irrespective of whether the body is buried or cremated. Fifth, there should be more informative and accessible outcomes for inquests. The recommendations here included more flexibility over the scope of the inquest process, more involvement of the senior judiciary in exceptionally difficult and complex cases, fuller conclusions from inquests with a stronger bias towards narratives and preventative findings, and a fairer and more consistent rules on disclosure. 6, it recommended proper recognition for the work of coroners' officers and the provision of training for them. One observation I want to expand upon was that bereaved families have often had very limited opportunities to participate and have often been treated very poorly by the system. A stark example and an infamous example was the inquest into the Marchioness disaster in 1989, where a riverboat sank on the River Thames and many young people died. The coroner famously described the families of the victims as mentally unwell and described the mother of one victim as unhinged. He then refused to recuse himself, as a result of which the families brought a claim for judicial review, which ultimately succeeded. Unhappily, this was not an isolated incident. Families have sometimes been treated with thinly disguised contempt throughout the death investigation process, from beginning to end. As my late colleague, Ian MacDonald of Queen's Counsel, said in 2001, quote, "I note the insensitivity and the rudeness with which people are given news of their relative's death, which is utterly inexcusable. There are not many social skills required to do something more with dignity," end quote. In more recent times, the European Court of Human Rights case law has guaranteed the bereaved family's right to participate in an Article 2 inquest. And I explained what an Article 2 inquest was in the first lecture in this series. But there are still often huge barriers to meaningful participation by a family, which I will expand upon later. The then Labour government did commit to acting on the Luce report. Harriet Harman MP delivered a blistering critique in the House of Commons in 2006. She said, quote, "Under the current coroner's service, families frequently get overlooked during the inquest process. There is nowhere for them to turn when they think that something is going wrong. There is no complaint system. The system is fragmented with no national leadership, and it is not accountable. We have no overview of the system as a whole or of individual cases. Moreover, the system is not properly accountable to this House, which it should be. Standards are not uniformly good. Everything rests too much upon the personal qualities and abilities of the individuals within the system. The legal framework is damn right archaic," end quote. But to cut a long story short, these proposals ended up being significantly watered down. The Labour government brought forward a reform bill which became the Coroners and Justice Act 2009. Now, don't get me wrong, this act went some way towards professionalising the coronial service, but not nearly far enough as the Luce report had advocated. It did create the office of a chief coroner, as the Luce report had recommended, but it did not create a national coronial service. Coroners are still appointed and paid by local authorities, and as we will see, many of the problems identified by Harriet Harman persist today. So, let's see how the system actually works. We're now going to talk about how it operates under the 2009 Act. There are three basic circumstances in which a coroner is required to investigate death, which are similar to those which applied before 2009. They are: if a deceased person dies a violent or unnatural death, if the cause of death is unknown, or if the deceased dies in custody or state detention. In some cases, a coroner has to hold an inquest, which is a formal judicial proceedings in court. Until the 2009 Act came into force, an inquest had to be held in every case where the criteria were satisfied. However, since the operation of the 2009 Act, the coroner now has the power to discontinue the investigation without holding an inquest if a post-mortem examination or autopsy shows the cause of death and the coroner thinks it's not necessary to continue the investigation. However, the coroner still needs to hold an inquest in every case if the deceased dies a violent or unnatural death, or if the death is in custody or state detention. It's an incredibly important role because the coroner is essentially the state's investigator, a position which can be very sensitive with organisations and also very political. At first blush, an inquest looks very much like a trial, but because it takes place in a courtroom, witnesses are called to answer questions. But the difference is between a civil and a criminal trial, civil and criminal trials are adversarial, whereas the inquest is inquisitorial. In a civil or criminal trial, the parties decide which witnesses to call, what evidence to put forward, while the judge is meant to be a neutral arbiter. However, in an inquest, by contrast, it is the coroner who decides what evidence, what witnesses to call, what evidence to consider. An inquest is also unlike a trial in that, in theory, there are no wins or victories, there are no losses or defeats. Instead, the coroner or the jury, if there is one, decide 4 essential questions: who the deceased was, how, when, and where the deceased came by their death. This used to be known as a verdict, but is now known, since the 2009 Act, as a determination. As we discussed in the first lecture, the scope of the inquest varies according to whether the case engages Article 2 of the European Convention on Human Rights, in other words, an individual's right to life. In a normal inquest, where Article 2 is not involved, the coroner is limited to deciding by what means the deceased came by their death, and is not to apportion fault or blame. By contrast, in an Article 2 inquest, such as one where a person has died in state custody or at the hands of state agents, the House of Lords case of Middleton established in 2005 that the task of the coroner is now much wider, and they have to decide in what circumstances the deceased came by their death, and this can include criticisms of state agents where the death could and should have been avoided. In the ordinary, smaller cases, there are a number of standard or short-form verdicts, or conclusions, as I should say, that coroners and juries normally use. Some of them you may have heard of: suicide, misadventure, accident, lawful killing, unlawful killing, death by natural causes. In some cases, the conclusion can be longer, known as a narrative, which is just a description in narration form as to what happened to the deceased and a description as to the circumstances in which he or she died. In past centuries, all inquests took place with a jury. Most inquests now take place in front of a coroner alone, and in fact, the most recent act says there's a presumption against sitting with juries. But a few inquests still take place with a jury. A jury inquest is required where a person dies in custody or state detention and their death was violent or unnatural or the cause was unknown. It's also required where the death resulted from the acts or omissions from police officers or state agents in the purported execution of their duty, or for notifiable accidents or diseases. A jury is not required for an Article 2 inquest if it doesn't involve a death in custody or at the hands of the police, although a coroner has a discretion whether to sit with a jury or not. The 2009 Act, as it was enacted by Parliament, created a right of appeal to the Chief Coroner against decisions of coroners, as the Luce report had recommended. But when the coalition government got in, they swiftly watered down the provisions of the 2009 Act, and this right of appeal has never been implemented. It's never been brought into force. There is still no appeals process. Both before and after the 2009 Act, the only way to challenge the judicial decisions of the coroner during the course of an investigation is to apply by way of judicial review, which is cumbersome, difficult, and expensive, or by way of an Attorney General's fiat, which is a process similar to judicial review. So, has the 2009 Act worked? From my perspective, as a inquest practitioner, the 2009 Act has made some concrete improvements. The coronial service is now more professional. Coroners are now better trained. Coroners' officers are now better trained. And the chief coroner has a very important leadership role. But there are still lots of problems arising from the fragmentation and the localisation of the coronial system. These include the following. First, there's still too much variation between different local authorities as regards the quality of the coronial service. Some coroners still have very poor facilities and minimal staff. As the publication Unlocking the Truth, a report by Inquests, the charity, explained, coroners' courts are frequently, in particular, remote or in badly serviced areas. Many still have a lack of refreshment facilities. One family member of a person who died said in the report, "The police had lunch laid on while we had to take ours in with us and had to walk into town." Many courts still have no private waiting areas, so families have to have private conversations in corridors. Inquest, the organisation, has said that the lack of space, private space, has been particularly distressing for families where they've had to wait or discuss their case in the close proximity to the people they believe may be responsible for the death. Unlocking the Truth was published before the 2009 Act, but this still continues to be a problem in my experience after the 2009 Act. Second, in cases involving deaths at the hands of the state, families often feel that the coroner and the authorities are in close ranks against them. I'll give you an example. I did a horrible case in the early 2000s where a child died in a police station. The family were understandably suspicious about the police account of events. This, of all cases, was one which called for sympathy with the family. But when we got to court on the first day of the inquest, there were literally 2 rows of police officers outside the coroner's court, ostensibly providing security. The family had to walk the gauntlet into court through these 2 rows of police officers. As you can imagine, that created a strong feeling that the system was closing ranks against them. That feeling was confirmed when the coroner was hostile. Sometimes the very cases where the bereaved family is most traumatised are the cases where they're treated the most poorly. And at times, the race of the deceased and the family is sometimes suspected to play a role in this. Another factor that contributes to this is that coroner's officers are usually police officers or local authority staff on secondment. This means that the coroner does not do his or her own independent investigations. It can create an appearance of lack of independence, particularly when the police or local authority are involved in the death that is being investigated. Third, there's a lack of consistency between different coroners as to how inquests are conducted. The law gives the coroner a wide discretion as to how to conduct the inquest. As Sir Thomas Bingham said in the case of ex parte Jameson in 1995, it's the duty of the coroner to ensure that the relevant facts are fully, fairly and fearlessly investigated. He is bound to recognise the acute public concern rightly aroused where deaths occur in custody. He must ensure the relevant facts are exposed to public scrutiny, particularly if there is evidence of foul play, abuse or inhumanity. He fails in that duty if the investigation is slipshod, perfunctory or superficial. But the responsibility is his. He must set the bounds of his inquiry. He must rule on the procedure to be followed. Forgive the he's. That obviously relates to he's and she's. From my experience working with bereaved families, some coroners are very good and the family is very happy with them, while other coroners can be rude, hostile and downright unjust. Fourth, the appointment system lacks transparency. Coroners are appointed by local authorities rather than centrally. Don't get me wrong, it isn't as bad as it used to be since coroners' positions are now advertised, but there's still a perception that coroners are recruited from within a small circle. Can I use the Cornish coroner as an example? A succession of members of the Carlian family have held the office of coroner, going back to Victorian times. The current coroner, Dr. Emma Carlian, good evening if you're watching, Dr. Carlian, is the current senior coroner, is the daughter of the former coroner. Her father, Edward Carlian, and her great-great-great-uncle, Dr. John Carlian, was the first in the Carlian family to become the Mid-Cornwall coroner in 1837, followed by his grandfather, Edmund, in 1896, and his father, Lawrence, in 1935. This is not a criticism of the current or former coroners, but in the modern world, the existence of a de facto hereditary office may well give rise to public concern. People may well ask whether it is really likely that the best qualified person for the job happens to be the near relative of the last person to have the job. Fifth, the post-mortem process can be upsetting for families. Families are often provided with little information about the post-mortem, and in some cases, the use of invasive procedures may be contrary to the family's religious and cultural beliefs. Now, the new Act and the new coroner's guidance says that this should be something that's taken into account, but there's still problems with this. Recently, there had to be a judicial review in relation to invasive post-mortems because a coroner refused to follow the chief coroner's guidance. One bereaved family, quoted in the inquest report Unlocking the Truth, said this: 16 months after he had died, I was informed that my son's organs, his brain, heart and lungs, were sitting on a shelf somewhere. We were absolutely devastated. I kept my son's ashes at home, so he would always be with us, but now I could no longer keep him at home because he wouldn't be complete. No ashes would come from his organs. So I had to arrange for him to be in a cemetery for his organs to be buried with his ashes. So all you go through with the first funeral, you have to go through it all again with the second. I'm going to talk about how we can improve the inquest process, and I'm going to start with a caveat. As we've heard earlier, the office of the coroner, like the rest of the English legal system, was created by and for the ruling class. It was historically filled with members of the landed gentry. Our legal system's main function for hundreds of years has been to protect the powerful and the privileged, and it has done so very effectively. So when we try to reform and improve it, are we just putting lipstick on a pig? Are we wasting our time? My answer is both yes and no. Reforming the office of coroner will not bring the fundamental societal change we need, but it will make things better for the present moment for some bereaved families during the most terrible times of their lives. So what should we do? My view is we should implement the Luce Report's recommendations and create a single, unified, independent national coronial service. The leadership role of the chief coroner should be strengthened, and the deputy chief coroner's role should be implemented. Within the National Coronial Service, we should create a cadre of experienced senior coroners who deal with state-related deaths and other high-profile and difficult cases. And we should create a right of appeal to the chief coroner against decisions of coroners during the course of an inquest or an investigation. The National Coroner Service should be supported by a permanent staff of coroner's officers who work directly for the coronial service, not for the police, not for the local authority. And perhaps, and most importantly, we need to centre on bereaved families in the inquest process. Legal aid, the elephant in the room. Any investigation of death and who conducts it cannot ignore that elephant in the room, namely funding. The lack of proper legal aid funding is one of the most fundamental problems in this area. In high-profile, often controversial inquests, the institution responsible for the death, whether it be the police, prison service, NHS trust, or a private company, is going to be represented by an expensive team of lawyers, usually headed by Queen's Counsel. Even though an inquest is theoretically inquisitorial rather than adversarial, powerful institutions frequently fight hard in the courtroom to absolve themselves of blame. Yet the family of the deceased does not have an automatic right to legal aid. Legal aid is often means tested, so they have to disclose information about their financial circumstances. Often, we have to fight hard for the family to get legal aid. And then there's a further problem, which sometimes arises. In an inquest which engages Article 2, the right to life, such an inquest where somebody's been killed in state custody or by state agents, the family of the deceased may be able to get legal aid, and in some circumstances, the means tests can be waived. But what if the family is dissatisfied with the decision the coroner has made and wants to challenge it? In general, the only way to do this is to apply to the High Court for judicial review. And while there is legal aid for the judicial review claims, there is no discretion to waive the means test. So, if a family is earning slightly too much to be eligible for legal aid, and believe me, the means test, you literally need to be living in poverty, but not enough to pay for the litigation themselves, then they simply cannot bring a challenge, especially as, if they lose, they don't have legal aid, they will be ordered to pay the opposing party's costs, which can be substantial. The charity Inquest, which does great work with bereaved families, has been campaigning for years to have automatic, non-means-tested legal aid for families in all Article 2 inquests. I fully endorse that campaign. We need equality of arms and fairness for families, and the only way to achieve that is to ensure that families have high-quality legal representation. We also need to implement the Luce Report recommendations for a right of appeal to the Chief Coroner. Let me just turn briefly, if I may, to the appointment of coroners. We need an open, transparent appointment system. That's not to say that the centralised appointments system for judges is working well. I have frequently pointed out that appointments to our senior judiciary is still disproportionately white, male, privately educated, and from a narrow range of professional backgrounds. That is a subject I will turn to in a later lecture. But while we need to reform judicial appointments generally, the appointments of coroners by local authorities is particularly unsatisfactory. Now, I want to just touch, if I may, very briefly about the relationship between inquests and inquiries. Another benefit of the National Coronial Service would be that it would take over the role currently performed by public inquiries. At present, where there is a particularly high profile and or large scale death, the government will sometimes commission a public inquiry, think Grenfell. In my experience, having been involved in a number of inquiries, there are some major problems with them. First, the chairman, and it usually is a chairman, of the inquiry is appointed ad hoc by the government. This can give rise to a perceived lack of independence. Second, the chairman largely makes their own rules as to how the inquiry will proceed. There is little consistency between different inquiries. Third, the family's opportunities to participate is varied and often limited. Families' lawyers in some inquiries, Grenfell, are usually not allowed to ask questions of the witnesses themselves directly, and the role of the family's lawyer is more limited than in an inquest. With a new National Coronial Service and an expanded and improved inquest service, coroners would be able to handle even the most high-profile, complex, difficult cases. A key advantage of this process over the public inquiry would be that the National Coronial Service would be completely independent of government, and the coroner who conducted the investigation would be nominated by the chief coroner and not government. In my view, this would be a better process than the current inquiry system. Let me turn to juries. I cannot talk about who investigates death without looking at juries. Quote, "It takes courage to sit on a jury. How many of us would want to decide the fate of another person's life or freedom? How many of us want to hold that kind of power in our hand?" Quote from Regina Brett. You see, I've already indicated in a narrow number of inquests you have a jury. I would say juries are an under-acknowledged strength of our justice system. My experience of juries is that they are better than you might expect at getting their heads around complicated facts. And they are also fairer than professional judges. I have appeared before many juries in inquests, criminal trials and civil trials, and my experience is that in a case where the cards may be stacked against you, for example, you think you're going up against the state, you're generally better off with a jury than with a judge. There is some empirical evidence to support this. The Lammy Review in 2017, which investigated racial inequality in the criminal justice system, for example, crunched the numbers and made the interesting finding that juries were not systematically biased against black and ethnic minority defendants. There was no evidence of racial disparity in juries' decisions to acquit, to convict, or acquit. This contrasted with sentencing, where there was significant racial disparity between who got sent to prison, particularly for drug offences. Obviously, this data relates to criminal trials rather than inquests, but my anecdotal experience suggests the same is true in inquests. During my career, I've appeared before some juries who were unafraid to make fearless criticisms of those in power. My view is that a jury inquest should be a norm in every Article 2 case. So let me conclude and sum up. Our coronial system has many strong points. It is better than many systems around the world for investigating deaths. The role of the coroner as an independent judge is an important and valuable one, but it could be improved. We need a national coronial service led by the chief coroner. Coroners should be centrally appointed and paid and should be supported by permanent professional staff. We need a right of appeal against decisions of coroners, and we need to expand the role of juries. And most importantly, we need automatic, non-means-tested legal aid for every Article 2 inquest. If we can make those improvements, we'll have a system of death investigations that is truly fit for the 21st century. So now I'm coming to the end of this lecture. I want to tell you an uplifting story. It's a story about one of the best experiences in court I ever had. And I shall name and praise the coroner in question. His name is Mr. Geraint Williams. He was conducting an inquest in Worcester into the death of a man known as Martin Green. It was a horrible death where Mr. Green literally starved to death while in prison, and the prison staff ignored his condition. Mr. Green's young child, who was brought to court one day, at the end of the day, the coroner invited the child into the courtroom after the proceedings, and the child sat up with the coroner. This was in front of all the lawyers in the court, representing 8 or 9 different interested persons. And the child said, "Are you going to find out what happened to my daddy?" And the coroner said, "Yes. You see all these people here? They're here to help me find out how your daddy died." Everyone in the courtroom could not help themselves but shed a tear. There wasn't a dry eye in court. This was an example of real compassion and real human understanding. Unfortunately, not all coroners show this level of care, understanding, compassion, and human decency. I know it's not an easy job. James Baldwin said, "If one really wishes to know how justice is administered in a country, one does not question the policemen, the lawyers, the judges, or the protected members of the middle class. One goes to the unprotected, those precisely who are in need of the law's protection most, and listens to their testimony." Wouldn't it be interesting if coroners were to listen to the users? Thank you.
Professor Thomas, thank you very much for a really thought-provoking lecture. We do have a few questions from our online audience. The first one is from John Welch, who says, "I work as a forensic scientist, and the use of forensic science by coroners seems rather haphazard. In particular, any suicide note should be examined by a qualified document examiner. Would Professor Thomas comment, please?"
I have to agree. I think the difficulty is, firstly, not all coroners are equal. So you have a large variation across the country in relation to just how detailed a coroner will conduct their investigation. Secondly, and I fear that this has a lot to do with the differences in instructing experts, is funding. Remember, I said to you, local authorities fund coroners, and coroners' resources are tight. And tragically, I think that a lot of investigations are not really led by where the evidence should take them, but by where the resources take them. But perhaps I'm being unfair.
Thank you. The next question says, IOPC findings and coroner's PFD are only recommendations. How can we ensure broader learning and improvements when there is no recognized oversight of these actions?
I think that the PFD system needs to be strengthened. I think that they should be mandatory. I think that the public and the media need to play a greater part. I'm a real proponent of carrot and stick. Praise where praise is due, stick where stick is due. And I think, I agree, I think that one of the difficulties, certainly before the 2009 Act, it's improved a little bit, that there needs to be wider publication. I'll give you an example. I have been involved in, as many will know, many restraint deaths. There is a lot of learning in relation to restraint deaths, and there are many, prevent death reports. That's what PDF means. But there doesn't appear to be any uniformity or collective knowledge bringing these reports in. So you can have similar deaths happening in different parts of the country, where one part of the country learns and another part of the country doesn't learn, and there's no bringing together of that knowledge. I think that needs to improve.
How can we ensure that there is more space for bereaved families to express their righteous anger within otherwise cold, unemotional official processes such as inquests?
It comes back to what I was saying about the understanding of human behaviour, the bereavement process. Some coroners treat the coroner's court as if it was a criminal court or, a civil court. It's not. It's a court that deals with death, unlike criminal courts where you're dealing with punishment. And I understand why you would need to have particular codes of conduct and etiquette in a criminal court. I get that. But in a coroner's court, where you're dealing with somebody's death, people are going to be very emotional. They are going to, express grief, and grief comes out in different ways. And I've given the example in the lecture of the two very different ways that two different coroners treated an outburst by a family member, and very different responses. One was treated with real humanity and understanding, the other was not. And the reactions of the family were very different.
At an inquest into a death that occurs in police custody, in what circumstances is it reasonable for a coroner to grant anonymity to police officers? How might anonymity influence the jury's perception of the deceased and the jury's experience of the inquest?
It's a very difficult question. Generally speaking, anonymity is granted to witnesses where there is good reason. Good reasons, for instance, in a police case may be if a police officer is a firearms officer, and if their identity is known, it effectively renders them useless as a firearms officer in the future because they need to be undercover, for example. So that might be a good reason. Another reason might be if there had been a particular threat made and that witness is in genuine and reasonable fear of their life, safety, or the safety of their family. So there are times when anonymity is fully justified. My fear is, in a number of recent cases, coroners have been too easy to grant anonymity and not been discerning enough to see whether or not it's truly merited. And to come to the question that you asked, how might the jury see that? How might the jury see the family? There's a real danger that they might feel that the family are somehow criminalised, which shouldn't be the case. And that's really incumbent on the coroner to explain to the jury that that isn't the case, that there are good reasons I've explained, for instance, about somebody needing to remain anonymous because of their role in their job. If that's done and that is explained to a jury, I think that should cover those difficulties.
How hopeful are you that there will be meaningful improvement in the inquest procedure?
I've been doing this for 30 years, and with each year, things have improved. But there is no room for complacency. There's a long way still to go. I would say this, it's completely different from when I first started doing inquests about, as I say, 3 decades ago, when there was real hostility to those representing families. There was no legal aid, there was no disclosure. I remember the very first inquest I went into, the coroner was hostile, all the interested persons had documents and large bundles. I had nothing, I had a back sheet, and I had to cope. And many people will remember those days. We've moved away from those days. We've got disclosure, we've got some limited legal aid. So we're moving in the right direction, but as I've indicated in the lecture, there's still a long way for us to go.
How is the Home Office autopsy recorded? Video? Dictaphone?
It varies. Some Home Office pathologists are now beginning to record their findings. Some do it by, for a long time it was done by photographs. I'm quite sure some pathologists will, make a recording of their autopsy. So it varies.
A few more questions, if that's all right. Are you aware of any cases where a coroner has had to recuse themselves on the grounds of actual apparent bias, on the basis either that the death is police-related and the investigating coroner's officers were of the same constabulary, or the death is health/social care related and the host local authority is a connected health social care commissioner and/or provider?
I'm not personally aware of any cases, but I'm sure there are cases. I can give an example. There was one case that I was involved in which meant that there were real criticisms of the local authority. The very same local authority that was funding the inquest. And it was in relation to a death of a child and whether or not there had been failings both by the police and by the local authority in terms of child welfare. And the coroner in this case actually instructed me as counsel to the inquest. And the reason why he did that was he wanted me to deal with the witnesses in a fair and robust way, so there could be no suggestion that if criticisms and difficult questions, robust questions needed to be asked of the local authority, he couldn't be accused of, not doing that, which is, I think, one of the reasons why he instructed counsel like me. So that is one case, and that's how one coroner did it. But so he was obviously cognizant of the potential conflict. But as I say, I'm sure there are cases where a coroner may recuse themselves and refer the matter to another coroner.
As you touched upon, it feels as though inquests can be adversarial, whereas all parties ought to be aligned in wanting our institutions to work better. Why is this not the case, and what can make it better?
You're right. Despite the fact that an inquest is meant to be inquisitorial, an inquiry to get at the truth, anybody who's been to any controversial inquest, and when I say controversial inquest, pick any death in custody, pick any police shooting, pick any restraint case, they are fairly adversarial. And the reason for that is where they need to be at times when you're testing the state's account in relation to how a death has occurred. Remember, it's often said, and I often say, that the dead cannot speak for themselves. Somebody has to speak on their behalf. Usually where you have these deaths, the witnesses to the death are generally agents of the state. If you think about a death in a prison, it's generally prison officers who are the witnesses. If it's in a police station, it's generally police officers. And their evidence has to be tested robustly. And that may give an adversarial flavour to the questioning. So that's one reason. But another reason is, and come back to the question that you've asked, why aren't we all looking for the truth? The reality is that many organisations, institutions, agencies are very defensive of their reputations. They lawyer up. As I've indicated in the lecture, it's not unusual to see large organisations being lawyered up with silks, Queen's Counsel, that's the most senior advocates, and junior counsels and teams of solicitors all supporting themselves. And they will do what it takes in defence of their reputation. Often, that's regardless of the issues in the case. And sadly, I have to say, there have been times when the sensitivities of the family, let's say, who should be at the heart of an inquest, are forgotten.
Should coroners be required in carrying out their duties to show compassion where appropriate? And if so, what specifically would this require? Should the requirement be enforced, and how?
Well, I'm not saying that coroners should be punished or anything like that. My view is coroners need to have compassion for a job which deals with bereaved people. So there needs to be better training and understanding. And I think what we need to do is at the recruitment, appointment stage, I think coroners need to be tested on that. And if it's clear you don't have the right temperament for the job, you shouldn't be appointed. Because I cannot see how you can do this job unless you are a compassionate person. You're dealing with people who are bereaved and in grief. And I'd be surprised if the majority of coroners disagreed with that. I think the majority of coroners would agree with what I'm saying.
And just one final question. Are Home Office registered forensic pathologists really as independent as they are supposed to be when they are hired by families for an independent autopsy?
Yes, I think they are. I've come across forensic pathologists who make it absolutely clear, they're not hired guns, and they will tell you if a family hires them, they are given evidence to the court. They're not given evidence for the family. And there are some very good forensic pathologists who don't have a problem saying, look, the evidence is not what the family think it is, and they allay rumours and suspicion. So I think on the whole, you know, you have good and bad in every profession, and yes, I have come across some awful pathologists, but on the whole, I think that pathologists do recognise that they are experts for the court, and they're given evidence to assist the court, not given evidence for one side or the other, or another side.
Professor Thomas, thank you very much for your lecture this evening and for your generosity in answering so many questions and staying a bit longer to do so. I know our audience really appreciates that. And for our online audience, thank you for attending. The next lecture in this series is There a Level Playing Field at Inquests? From Death on the Rock to the Birmingham Pug Bombings. And this is on Thursday, the 4th of February at 6 p.m. So please do join us for that one. Thank you.